All right, everybody, welcome to government class today. I am so disappointed that I can't be here to talk about this with you guys in person, but as you can probably hear, I seem to have picked up maybe a bit of a virus. So, in the spirit of good faith and making sure you guys know exactly how to tackle a case breakdown like this, I'm going to walk you through just a skimming of the facts. This is keeping in line with what we did yesterday, where you worked through the basic vocab of a case breakdown or the breakdown of sequence in the Supreme Court. And now we are actually tackling a very unique Supreme Court case. You might find it applicable to your life someday in the future, too, as we discuss Florida v. Jardines. And in this particular case, the state of Florida is suing a resident of the state, one Mr. Jardines, originally rooted here. 2006, Miami, Florida. Anonymous tip: a man was growing illegal marijuana in his home. The police approached the house with Frankie, the dog, the drug detection dog. They bring the dog up to the front door. Frankie sniffs at the door and indicates that, yeah, he detected the presence of marijuana inside the home. Now, using only this evidence, the police obtain a warrant. They do find that Jardines is guilty of growing marijuana plants, significant value within his home. They arrest him and they charge him with marijuana trafficking. Now, as this processes through the lower courts, it starts at trial court, criminal trial court. At trial, Jardines' attorney argues that the dog sniff was a search under the Fourth Amendment, and so the police should have had a warrant to bring the dog up in the first place, not just the warrant to investigate his home, enter his home, but also to have the dog there, because every search under the Fourth Amendment requires a warrant. However, or I'm sorry, yes, the court trial agreed. They threw out the evidence and ruled in favor of Jardines. However, the Florida Appellate Court, the attorneys for the state of Florida, resued. They appealed upward to a court with more jurisdiction and argued exactly the opposite. Bringing a dog to the door did not constitute a search. Well, now the Florida Appellate Court agreed. And we end up then with Mr. Jardines' attorney appealing again, now to the next highest level of court, the Florida Supreme Court, arguing once again that bringing a drug detection dog onto private property right up to the front door constitutes a search. The Florida Supreme Court was divided, but they agreed with Mr. Jardines' attorney. If you're keeping track, that is 2 wins for Jardine, 1 win for the state of Florida. And now, the state of Florida has appealed again. There's only one court left with more jurisdiction to finalize this decision. That is the Supreme Court of the United States. The question at hand is under the Fourth Amendment, part of the Bill of Rights. The Fourth Amendment regulates how much authorities can seek out evidence of a crime against you. It protects you from unreasonable searches and seizures, that you are allowed to be secure, quote, in your person, meaning anything on your body, anything marking your body, housing within your own property, papers and effects, the things that you own, against unreasonable searches and seizures. So this is going to be a question of probable cause. Is there a good reason to believe someone has done illegal? And then secondly, the follow through on that. Is there a legal document, a warrant giving that permission to search? If we determine as a court that the police failed in either of these regards, then any evidence has to be thrown out, and the court will likely rule in the favor of Jardines. This isn't us against Jardines. We're not trying to seek one side or the other. We're just simply trying to determine this point. Did the police fail legally, constitutionally, to search and seize properly? So, When police bring a trained narcotics dog to sniff at the front door of a home, is that a Fourth Amendment search? Once you have this information all taken in, the very next step, as we know, is the legal, or not the legal briefing, plenary review. We have to, now that we've heard the legal brief on the case, start to examine past decisions that past courts have made and see if we can find any pattern or precedents from these previous cases. You have 5 laid out in front of you, and by Monday, I'm going to ask that you have each one completed. I'm going to show you a really good way to tackle the first 1 or 2 of these here. All right, so as we read the first one, we can see it's from 1967, Katz v. U.S. In the FBI suspected that Charles Katz was placing illegal bets from a public telephone. They used a listening device on that telephone and convicted him of illegal gambling. Katz's attorneys say his right to privacy had been invaded, had been squashed upon, that there was a warrantless search, so this issue is going to come before the warrant issue here, and that the court should throw out any evidence the FBI had gotten. In the Supreme Court agreed, finding that the Fourth Amendment protects people, not places, and that when an individual has a reasonable expectation of privacy, like on a private telephone call, despite the fact that it was a public, and that when an individual has a reasonable expectation of privacy, like on a telephone call, the government's invasion of that privacy constitutes a search and therefore requires a warrant. So what do we got? Facts of the case. We should start with the facts, and then we'll try and figure out the question of the Constitution, or the constitutional question at hand, and then the conclusion of the case. What did the court decide? Facts. We know that Katz was placing bets using public telephone booth and a listening device was planted on that booth, leading to Katz's arrest being used as evidence. The question at hand: does that listening device as evidence invade Katz's privacy under the Fourth Amendment? I'm going to make this all a little bit smaller here. Conclusion, yes, that Katz should expect some degree of privacy on the phone. Should just expect some degree of privacy, so the FBI should have gotten a warrant. Kind of going off the screen a little bit here. Let's see if we can cut this down a little bit. There we go. Should have gotten a warrant. All right. What we've done now is we are starting to make some connections to the original case itself. We are asking questions about when a warrant is, well, needed in the first place, to what extent somebody can expect privacy. In this case, Katz himself, being the person, expects a certain level of privacy when he's on even a public telephone because he's making a private call. And so the Fourth Amendment holds up here. That's our most continuous connection here, the Fourth Amendment, and to what extent it protects your right to privacy. Let's do place, U.S. for place as well, and then I'll give you some time to work on the remainder of the packet here. Facts of the case. Here's what we got. U.S. v. Place, 1983. Authorities seized luggage from a man at an airport in New York, brought a trained narcotics dog to perform a sniff test. They found, based on this, narcotics on the man, arrested him, and through a series of appeals, this issue ends up before the Supreme Court. The Supreme Court held that when authorities have specific facts supporting reasonable belief, the government may seize that luggage to pursue further investigation and perhaps an arrest. The Supreme Court also decided, however, that the dog's sniff of the luggage did not constitute a search and therefore did not require a warrant because the Fourth Amendment was in a place. And now we have this weird contradiction where up here the Supreme Court found that the Fourth Amendment protects people, not places, and yet in the very next one, the Fourth Amendment seems to be protecting the place, or at least diminishing a person's right within that place to privacy. So we're starting to see the contradiction that can be established and the way the Supreme Court can change its opinion over time from 67 here to 83, based on new interpretations of the Constitution, based on other precedents that have been established. Let's get the facts out so we have these two cases at least settled. At least we know what is going on in them. So there was a sniff test on luggage in an airport and an arrest. No warrants. Question. Does Fourth Amendment protect privacy of luggage in an airport? In a public airport, I guess I should say. Conclusion. No. Authorities with reasonable belief, and we come back to that reasonable issue now. Here we talk about probable cause. Authorities with probable cause or reasonable belief may seize luggage, and a sniff test does not require a warrant because it is considered not a search. It is not considered a search under the Fourth Amendment. All right, the rest of these here, I'm going to ask you to do the same thing. Facts, question, conclusion, and then to finalize your homework today, make sure you do answer this question: how has the Supreme Court treated Fourth Amendment searches in the past? I would include somewhere in here patterns and contradictions. On beliefs about probable cause and on necessity of a warrant, as in you should make your answer somehow a response to that prompt. Discuss patterns and contradictions about beliefs about reasonable suspicion, probable cause, and how necessary a warrant is under the Fourth Amendment in each of these cases. And then last thing for homework, right next to this cute, adorable canine unit here, please answer these guiding questions to review the case itself. We're breaking it down in a much similar way here, talking about the facts of the case, who's involved, what the Constitution has to say about the case, and then it asks you to compare what two precedent cases are most similar to this case, asking you to establish which ones you're most likely to use as evidence when you make a decision on this case. That's all, folks. This is both these pages are due on Monday. Please make sure you have them completed by then. And on Monday, we will start to hear the oral arguments. Have a good weekend, guys.